Okay, welcome to the Law Enforcement Data webinar with the Data Practices Office. Thank you for joining us today. If you've been watching our previous webinar series, you're familiar with the Data Practices Office by now. We are a resource on all things data practices and the open meeting law. Most of what we do is answer questions about both of these laws. We also provide training on different data practices and open meeting law topics and are now offering these short webinars. Today's webinar is the first in our 5-part series on law enforcement data. We record all of our webinars and post them on our YouTube page. I'm going to share my screen with you to walk through how to access our webinar content. The link that I will use to access our website is listed on this slide for you. Okay, so we're now on the Data Practices Office website where you can find several different resources about data practices and the open meeting law. If you're looking for some of our webinar content, you'll want to go up to News and Events, highlight Events, and then click Webinars. If you start experiencing any audio issues during the webinar, you can find some of the FAQs that may help you right here. Otherwise, we are also recording this presentation and you will be able to view the webinar later. To view our recordings, you can either click on the Data Practices Office YouTube channel link right here, or you can scroll to the bottom of our page and click on the YouTube icon. Clicking on that now. Okay, when you're on our YouTube page, you can access all of our videos on the Videos page, or you can go right to Playlists, where we will have this webinar series. You can see the Open Meeting Law series is already posted, as well as our previous series on government personnel webinars, our government personnel webinar series. We'll be posting today's recording within the next day or two, so that should be appearing here soon. If you'd like to download a copy of today's PowerPoint, I'm sharing a file of the PowerPoint right now for you to download or save to your computer. Okay. A pop-up window will appear, and then you can choose to download and save this to your device. But don't worry, we'll also share this file near the end of the webinar for those who join later or miss it this time around. So if you don't get it downloaded, we will share it once again at the end of the webinar. Okay. As I mentioned, today's webinar is the first of 5 webinars focused on law enforcement data that the Data Practices Office will be presenting over the next several months. Today, we are going to discuss some basics about the Data Practices Act to get everyone on the same page, the classification of different types of law enforcement data, as well as requirements to protect identities of some individuals. We'll also have some time at the end for your questions, so please feel free to send them in. When sending us questions, please send them to all panelists so we can be sure to see them. In future webinars, we are going to discuss the classifications of different types of video data that law enforcement agencies create and maintain, miscellaneous issues involving law enforcement data, and data practices requirements involving law enforcement data about juveniles. So if you have questions on these topics, we're going to ask you to wait until those webinars. If you send us questions on those topics today, we will probably hold off on answering them, but we may try to incorporate the questions into a future webinar in this series. If you have a question that can't wait or you don't want to ask now, please always feel free to call or email our office. Okay, let's start with a quick slide on data practices laws to orient ourselves in the discussion for today. As most of you know, the Minnesota Government Data Practices Act is in Chapter 13 of Minnesota statutes. It applies to government entities as well as private entities under contract to perform government functions. It presumes government data are public, and it classifies some data as not public, as do other statutes. It provides different rights for members of the public and data subjects, and it also requires that data about people be accurate, current, complete, and secure. The administrative rules implementing the Data Practices Act are found in Minnesota Rules Chapter 1205. The rules specifically apply to data on individuals, which is data about people, and contain helpful guidance, particularly in the area of law enforcement data, because much of law enforcement data is data on individuals. So, what is government data? The Data Practices Act defines government data as all data collected, created, received, maintained, or disseminated by any government entity, regardless of its physical form, storage media, or conditions of use. In other words, government data are any information that is recorded and in the possession of a government entity. For example, government employees' email messages are government data because they are data that is created or received by a government entity. Meanwhile, an in-person conversation between a law enforcement officer and a citizen about a parking meter is not government data because it is not recorded. However, any notes the officer wrote about the conversation is government data because it was created by a government employee and is recorded. One other reminder, government data is presumed to be public, which means most government data is available to anyone who asks for it unless a state or federal law says otherwise. So let's turn to categories and classifications of government data. Government data are defined as either data on individuals or data not on individuals, and all data falls into one of these two categories. Data on individuals includes all data in which a person can be identified as a subject of the data. For example, the name and address of an arrested adult and a booking photo are data on individuals. Meanwhile, data not on individuals includes all other data that is not about a specific person. Data about the make and model of police vehicles or the building plans of a new detention center are examples of data not on individuals. Additionally, all government data, including law enforcement data, is classified into one of three categories of access. First, public data is available to anyone for any reason, and public data can be either data on individuals or data not on individuals. An example of public data is adult arrest information. Anyone can have access to this type of data upon request, and government entities cannot ask for a reason why the requester would like access. Next, private data on individuals or non-public data not on individuals are available only to the data subject, those in a government entity whose work assignments reasonably require access to the data, other entities that are specifically authorized by statute to access the data, or by those who are authorized by the informed consent of the data subject. An example of private data are peace officer records of children, which are not available to the general public, but are available to the data subject, as well as others as authorized by law or informed consent. Finally, confidential data on individuals or protected non-public data not on individuals are available only to those in a government entity whose work assignments reasonably require access to the data, as well as other entities that are specifically authorized by statute. Importantly, confidential or protected non-public data are not available to the data subject. An example of confidential data is active criminal investigative data, which is available only to government employees within the law enforcement agency who need to access the data for a work assignment, or other entities who have specific statutory authority to access the data. However, data subjects are not permitted access to active criminal investigative data that is about them. Next, Taya will discuss provisions of the Data Practices Act that specifically govern adult law enforcement data.
Let's turn now to Section 1382 and adult law enforcement data. We are going to discuss juvenile data in a future webinar, so watch for that. Again, feel free to send your questions our way, and we will talk to them, or we'll answer them at the end of our chat. If we get to the end of our time today and we haven't answered any questions, we will continue to answer the questions, and then they'll be on the recording for you to watch at a later time. Section 1382 applies to agencies that carry on a law enforcement function. The section states that this includes, but is not limited to, police, sheriff, and fire departments, the BCA, State Patrol, the Post Board, certain functions at the Department of Human Services, and the Department of Commerce. But this list isn't exhaustive, and Subdivision 1 does not give us a clear definition of a law enforcement function. So there are certainly other agencies that carry on a law enforcement function as well and would be subject to Section 1382. Is a prosecuting attorney someone who carries on a law enforcement function? There is a Commissioner of Administration advisory opinion from 2001 saying that prosecuting attorneys are law enforcement agencies and therefore had obligations to create and provide law enforcement data. However, there's an informal Attorney General opinion that says that prosecuting attorneys are not law enforcement agencies, and the AG opinion pointed to the legislative history showing that prosecuting attorneys were listed in 1382, Subdivision 1, and then removed by the legislature. So there are other provisions that apply to prosecutors, including Section 13.393, which is attorney data. And the result is simply that the data that prosecutors create as part of the criminal justice process are subject to these other provisions, and they are not creating law enforcement data. So let's talk about classification. We heard about the different classifications and how they drive access to data. One of the interesting parts of 1382 is that there are specific public classifications called out in that section, even though the general public presumption is not reversed with respect to law enforcement data the way it is for, say, personnel data or educational data. So we still start from the basis that all government data are public. The first question in determining classification is whether there's an active criminal investigation. If there isn't, either because the call did not result in a criminal investigation, maybe it was just a general call for assistance, or because there was a criminal investigation and now it's inactive, then law enforcement data are public, subject to a few exceptions. If there is an active investigation, then only the data that are listed in Section 1382, Subdivisions 2, 3, and 6 are public. We sometimes refer to these as super public data. Additionally, if the case is already in the court process, anything presented as evidence in court will also be public while the investigation is active. So let's walk through the super public data elements in subdivisions 2, 3, and 6. When there is an investigation that is active, these data are available to the public within a reasonable amount of time. The first provision is arrest data in 1382, Subdivision 2. This provision says that these data are public at all times in the originating agency. The policy, of course, behind this provision is that we do not have secret arrests, and the public can know who has been arrested. An important thing to note is that even though it's called arrest data, it also includes citations, incarcerations, or actions that substantially deprive an adult of liberty. So it certainly applies to actual arrests, but it also applies to these other circumstances as well. So you'll note on this list that it includes information about the arrestee, information about the law enforcement agency response, what kind of technology was used, if any. You'll also note that if the individual is a juvenile, that the only identifying information that is public are the age and sex of the juvenile. There are some exceptions to that, which, as I mentioned, we'll talk about in another webinar. But if you have an incident or a situation now involving juveniles, please feel free to give us a call or email us, and we can walk through those with you. 1382 Subdivision 3 is request for service data. Often these data are listed on an ICR or incident report. The nature of the request for activity, the name of the person making the request, unless it's a protected identity, which we'll talk about, the date and time of the request, and what happened as a result of the request. So these data are always public, even when there's an active investigation. Section 1382, Subdivision 6, sets out the superpublic response or incident data. Similar to requests for service data, these are data that are often found in police reports. These data basically include the who, what, when, where of an incident. Note that names and addresses of witnesses are public, unless they are protected identities. Phone numbers are not included here, so if there's an active investigation, then law enforcement would not have to provide witness phone numbers to the public. It also includes who responded to the call and a brief factual reconstruction of events. These additional elements are also public response or incident data. Similar to witnesses, identifying information about victims is public even while the investigation is active, unless it is protected identity. Use of body cameras is public. The actual body camera data are classified by Section 13.825. We will discuss videos also in a later webinar, but the fact that body camera data exists connected to an incident is public, while the footage itself would be classified under 13.825. Note there are special additional public data specifically about traffic accidents. Here it lists dates of birth, seatbelt usage, and alcohol concentration of each driver. So these data are public when there is an active investigation. Even though the public presumption is not reversed with respect to law enforcement data, 1382 subdivision 7 classifies any data not listed in subdivisions 2, 3, or 6 as confidential or protected non-public when the data are collected or created to prepare a case against someone. Remember that confidential, protected non-public are the most restrictive classifications, which means the subject does not get access. Only those within the entity who need it to do their jobs can have access, and those with statutory authority. So while an investigation is ongoing, data not listed in 2, 3, or 6 are generally confidential or protected non-public. Now, Section 1382 itself has several provisions that provide statutory authority to share active investigative data or that classify data differently. So we have our super public data in subdivisions 2, 3, and 6. Anyone can have those for any reason, even during the investigation. Protected identities are private, so no public access, but data subject access. Subdivision 15 allows law enforcement to share active investigative data for a public benefit purpose listed in that provision. Law enforcement can also share with each other, so police to sheriff, police to police, different departments, different cities or counties, if it's necessary and pertinent. That's a decision and a determination for the agency currently maintaining the data. Victims may request access to active criminal investigative data, and they need to make that request in writing to the prosecutor, not law enforcement. The prosecutor then decides if the release would interfere with the investigation or if the victim is going to engage in unlawful activities if they receive the data. So if either of those is the case, then the prosecutor must withhold from the victim. Otherwise, the prosecutor does have the discretion to release that active investigative data to a victim. And then, as I mentioned before, any data presented as evidence in court is also public. So that's active criminal investigative data. But once data become inactive criminal investigative data, subdivision classifies it as public, subject to the exceptions listed on this slide. So if access to data would jeopardize an ongoing investigation, then it maintains the confidential protected non-public classification even when inactive. Protected IDs, again, are private. Images and recordings that are offensive to common sensibilities are private. So if there are graphic photographs or recordings, a law enforcement agency can withhold that inactive criminal investigative data that would otherwise be public. Remember that this kind of data, offensive to common sensibilities, images and recordings, is private. That means the data subject gets access. So if the data subject wants access, or in the case of a death, if the family wants access, they are entitled to it. The decision and the determination about what is offensive to common sensibilities is up to the agency. Is a dead body always going to be offensive to common sensibilities? Is nudity always offensive to common sensibilities? These are likely going to be case-by-case determinations that each agency will make, and it's certainly possible that agencies in different communities may make those determinations differently. Subdivisions 8 through 11 of 1382, subdivisions 8 through 11, classify private data specifically related to criminal investigations into child and vulnerable adult maltreatment under sections 626, 556, and 626, 557. And as I mentioned before, body camera data are classified by 13.825. Other types of video are classified under 1382, just like any other kind of law enforcement data. So those are examples of exceptions to the general rule that inactive criminal investigative data are public under subdivision 7. So how does data become inactive investigative data? Data are inactive when one of the things on this slide occurs. Law enforcement decides not to pursue the case further, or after forwarding to the prosecutor declines to prosecute. Another possibility is that the statute of limitations is run. or the defendant goes through the court process and all rights of appeal are exhausted or the time to appeal has passed. One other circumstance that is not in the statute but would also make criminal investigative data inactive would be if the accused goes through the court process and is found not guilty or is otherwise exonerated. For those last two items that involve the court process, it's important to remember that there could be public investigative data that has been submitted to the court as evidence. So not all investigative data would remain confidential, protected, non-public through the whole court process. But this would be, of course, subject to any court orders a judge may issue as well. Let's talk about protected identities. 1382 subdivision 17 says that certain identities must be protected or may be protected in certain circumstances. In order to protect some identities under subdivision 17, law enforcement must make a determination that protection is warranted, and law enforcement agencies need to have procedures to document that. Identities are classified as private, so when law enforcement agencies are releasing public information, it's important to note that identity can be more than just a name. It also includes context and other identifying features. So law enforcement agencies should consider what other information identifies someone as we go through these identities on the next couple of slides. Some identities are automatically protected by subdivision 17. Law enforcement is always going to protect undercover officers. Also, victims of criminal sexual conduct or sex trafficking, they automatically get protection. A deceased person unlawfully removed from a cemetery, their ID is private. This is a situation that did actually occur, and the family was so upset by it that they went to the legislature and they got this language added. So now we have this provision in subdivision 17. Mandated reporter identities are also private. The ID of an individual calling 911 in a mental health emergency is private. And it's important to note that it is the person making the call that gets the protection. So if a caller is calling about someone else's mental health emergency, the caller is the one that gets the protection here. So the 911 caller in a mental health emergency, their identity is private, or if disclosure of the caller's ID would threaten the safety of a person or their property, then law enforcement can protect that identity. So that second bullet requires a determination by law enforcement and then a documentation of that determination. I also want to note here that these identities on this slide and the next one, as I mentioned, are in 1382, subdivision 17. But subdivisions 8 and 10 also automatically protect the identities of victims of child abuse and vulnerable adult abuse, which I mentioned previously. For the identities on this slide, law enforcement must make a determination that certain conditions apply. These individuals are individuals that don't automatically get protection. The first one is paid or unpaid informants. So if there is a safety risk to the informant, then law enforcement can protect. As a practical matter, an informant's safety may always be a concern just because they're an informant, but this is a determination that needs to be documented by law enforcement. Victims of any age or adult witnesses must ask for their identity to be protected. Otherwise, under 1382 subdivision 6, response or incident data, their names and addresses are super public. So they need to ask. Practically speaking, law enforcement can certainly inform victims and adult witnesses of their right to ask that their ID be protected. And then the law enforcement agency must determine whether revealing the identity would create a safety risk to that person or their property. So that's the additional step they have to ask, and then there has to be a safety issue. Juvenile witnesses don't need to ask, however. Entities just need to make the determination that the subject matter warrants protecting. So victims of any age, juveniles or adults, have to ask, but a juvenile witness does not. So that's just something to note. So those are the protected identities under Section 1382, Subdivision 17. All right. So that's actually our presentation for today. We're just trying to lay the groundwork for going forward for the next 4 parts of our law enforcement series. And now we have some time for questions. I see some are coming in, which is great. Please send them to all panelists. If we get to the end of our time today, again, as I mentioned, we'll continue to take some questions. And if you're unable to stay on, you can just come back and watch the recording and hear some of the questions. While you're thinking about your questions and getting your questions into all panelists, we just wanted to make a plug for another office at the Department of Administration, which is the State Demographic Center, which is leading the work on the 2020 census in Minnesota this year. An accurate count is going to allow Minnesotans to keep our representation in Congress and to get the funding for needed services. So you can find out more on this website here on this slide. I'm also going to put the PowerPoint back up at this point for those of you who missed it before. So I'll just set that up. That's available to download. And if you hear a pause while we're taking questions or some silence, don't worry, your audio is probably just fine. We're just trying to track questions and make sure we've captured all of them to answer now or to follow up later. So let's go ahead and start with the questions.
All right, our first question that we have here is, in relation to the super public data, what does public at all times mean in relation to the timing of availability? And the question states that often law enforcement agencies withhold this data in police shootings for extended periods. So with super public data, that 2, 3, and 6 data, that's always public, even when there is an active investigation. That just means that the data are classified as public, so anybody can access the data for any reason. Entities have an obligation to respond to data requests for public data in an appropriate and prompt manner and within a reasonable amount of time. There is a provision in subdivision 14 of 1382 that discusses withholding public data in certain situations. Subdivision 14 states that a law enforcement agency may temporarily withhold response or incident data from public access if the agency reasonably believes that public access would be likely to endanger the physical safety of an individual or cause a perpetrator to flee, evade detection, or destroy evidence. So if there's a situation like that, that could justify withholding some public data, that response or incident data, for just a temporary amount of time. But if an agency does determine that's the case, they receive a request for public data that they think will endanger physical safety of an individual or cause someone to flee, they have to provide a statement that explains the necessity for its action to withhold that public data when they receive that request. And then the individual making the request has the opportunity to challenge that in court. And then the court will determine whether the agency's action is reasonable. Okay, another question is, if an adult was not arrested, cited, or incarcerated, are the data listed below public? Date of birth, address, height, weight, eye color, hair color. So if you've collected this data, the data are inactive investigative data. Data are presumptively public unless there's a protected identity. So if you have that data about an individual, it's public unless their identity is protected. Okay, next question. If a case is inactive and closed by arrest and the court case is closed, should gang members' nicknames be redacted from the report? So again, inactive investigative data, those are presumptively public. You'll have to make a determination whether the individuals have protected identities under subdivision 17. If their identities are protected, then other identifying information about them would also be protected, such as their nicknames. Another question is, what constitutes a mental health emergency? Subdivision 17 doesn't define what a mental health emergency is. So this is going to be a determination for the law enforcement agency. They might have procedures or processes in place where that can help them determine what a mental health emergency is. But that'll be a determination for that entity, and it'll likely be very fact specific.
There's a question about it's not always easy to know what it was presented in court. What advice can you offer us here? I think that generally it's between the law enforcement agency and the prosecutor to stay in contact and to determine what has been presented as evidence in court and is therefore public, even maybe when you haven't gotten to the point where appeal rights have been exhausted. So I would just say stay in contact between law enforcement and prosecutors to determine which items are public because of that provision.
Here's a question that asks, is it all mental health emergencies, the caller or anyone else, or just a mental health emergency that the caller is experiencing? I think this is in relation to the identity of a 911 caller in a mental health emergency. That's protected identity. It just says they have to be calling to receive help in a mental health emergency. And so it could be another person who's experiencing that mental health emergency, but the caller's identity is the one that's protected.
There's a question that says phone numbers are not specifically called out. Are they presumptively public? So this is where we start with, is there an active investigation? I know that law enforcement sometimes goes out on calls and they're not actually criminal. There's not a criminal investigation that results. It's just a call for assistance, but it might not be criminal. So if there's not a criminal situation or a criminal investigation that's occurring as a result of a call or an incident, then the data are just presumptively public under the general presumption. So if a phone number were attached to that kind of incident, then it would be presumptively public. If there is an investigation that is active, phone numbers are not called out in the super public 2, 3, or 6 data. And so they can be pulled into that active subdivision 7 investigative data where they are confidential or protected non-public. So it's going to depend on whether there's an active investigation there or not.
This is a somewhat related question. It asks whether 911 callers' name and number are public data if it doesn't fall into one of the protected identity categories. So if you have a 911 caller, they're calling for a request for service. So some of their information is going to be super public data under subdivision 3, as long as their identity is not protected under subdivision 17. And that would mean their name and address of the individual making the call is public while there's an active investigation. When the investigation is inactive, there's not anything that's protecting their phone number once that becomes inactive. So once it's inactive, the phone number would be public as well. There's a question asking whether there's a guidebook that somebody can order as a reference guide. You can always order the data practices, laws, and rules, the printed book of the statute from the state bookstore, but I don't know of a guide that's available on law enforcement data. We do have a lot of resources on our website that we put out there, a lot of frequently asked questions, so you can always refer to that. We have quite a few YouTube videos on different law enforcement topics that you can look at, and you can always give us a call.
We have a couple people asking about how dates of birth are classified. This is one of those, there is some room here in terms of interpretation. So arrest data says, under subdivision 2, says that the age of an arrestee or somebody who's been cited or incarcerated, the age is public. It's super public. Usually what entities do. Some law enforcement agencies calculate the age. They have the age of the person. Some people use a partial birth date. Some agencies say, well, the data that documents someone's age is the birth date, so they provide the birth date. You'll notice under subdivision 6, however, response or incident data, that the phrase date of birth is actually used specifically for traffic accidents. So some agencies have interpreted that to mean that while age is public under subdivision 2, dates of birth are not necessarily public. So again, going back to if there's an active investigation and dates of birth are not specifically called out in subdivisions 2, 3, or 6, they can be pulled into that subdivision 7 confidential, protected, non-public, active investigative data. Again, it depends on the circumstances of when the request comes in and where you are in the incident or case.
Okay, there's a question on what constitutes an active investigation. The question states, cases that are active are classified as confidential data. If access to the data would jeopardize an ongoing investigation, then it's not available. My question is this: if a burglary occurs, law enforcement investigates the crime, makes an arrest, and sends a report to the attorney's office for prosecution. They're asking whether the case is then made inactive by law enforcement. So whether a case is active or inactive is determined by subdivision 7 of 1382. And it states that an investigation becomes inactive upon the occurrence of one of 3 things. So an active investigation becomes inactive if there's a decision by the agency or the prosecutorial authority not to pursue the case. You say you're not going to press charges, then the case becomes inactive. The expiration of time to bring a charge or file a complaint under the statute of limitations, that would make the case inactive, or an exhaustion of all rights of appeal by the person who's convicted. So if one of those 3 things occurs, then the case becomes inactive. Sometimes the case will become inactive because a prosecuting authority determines not to press charges, and then later down the road, they obtain additional evidence and they decide to pursue the case again and press charges. So in that situation, the case can become active again. Just because the case has been referred over to prosecution doesn't mean that it's inactive. It has to be one of those 3 things that occurs. Somebody asked about a situation where there are multiple data subjects with protected identities in a report, and there's private data on each of them, whether one data subject gets the private data on the other individual in the report. In those situations, the law enforcement agency should be able to redact private data on the individuals who aren't the data subject requesting the data. So if there's multiple data subjects, only the data subject who's requested the data gets data about themselves. They don't get the private data on other individuals. We have a question about the classification of 911 audio. So the actual audio recording of 911 call is private data on individuals, but a written transcript of the audio recording is public, and so somebody can request that a transcript be provided. Somebody commented in relation to resources on law enforcement data that the League of Minnesota Cities has a good publication on classification of law enforcement data. It's on LMC's website, so www.lmc.org.
Okay, I think we're going to take maybe one or two more and then call our time for today. Someone is asking if in vehicle crashes are drivers' names public under call data. So the names of parties are specifically listed in subdivision 6 for traffic accidents. So names would be public in addition to their dates of birth, their seatbelt usage, and alcohol content if that's relevant to the situation. And one final one, someone is asking, what if a case is not prosecuted, but there may be more evidence in the future? I think certainly cases kind of can come in and out of that active and inactive status. And so if you're in a situation where law enforcement has gathered evidence, maybe they've sent it to the prosecutor and the prosecutor says, I just don't have enough to go forward at this time, that then one of the conditions under subdivision 7 has occurred, and now it's inactive because the prosecutor has declined to prosecute. I'm assuming then something else happens in the future, you get more evidence, you talk to more people, and the prosecutor says, okay, I'm ready to go, we will go forward, then you're active again. So I think it is possible that data moves in and out of inactive and active status depending on what's happening with either law enforcement pursuing the case or the prosecutor determining whether or not to prosecute. We got a lot of great questions today, and there are some of them I know we didn't get to during the webinar. We will follow up with you. One person asked about CLEs. I will apply for CLEs for this, and then we can have that information available for you. Please provide us feedback on the survey that's going to pop up after you exit. Stay tuned for the notice for part 2 of our law enforcement series. And if you have any requests about other things we should talk about during these webinars, please do let us know. And we look forward to talking to you more in the future. Thank you.